हेलो एवरीवन, वेलकम बैक टू 𝐸𝐭𝐿𝐿𝐼C। आप सभी का 𝐸𝐭𝐿𝐿𝐼C पर बहुत बहुत स्वागत है। और आज हम डिस्कस करने जा रहे हैं बिहार सिविल जज का 2020 का क्वेश्चन पेपर। तो प्रीवियस क्वेश्चन पेपर की सीरीज हम दोबारा से स्टार्ट कर रहे हैं। इससे पहले हमने यूपी एपीओ, दिल्ली एचजेएस और दिल्ली जुडिशरी के पेपर्स कंप्लीट किए थे। उसके साथ साथ कर्नाटका जुडिशरी के पेपर भी कंप्लीट किए थे। कुछ कारणों की वजह से हम यूपी जुडिशरी के पेपर कंप्लीट नहीं कर पाए थे, लेकिन एक बार फिर से हम अपनी सीरीज ये शुरू करने जा रहे हैं और आपसे रिक्वेस्ट है कि प्लीज़ हमारे चैनल को सब्सक्राइब जरूर कर लें। तो अभी हम जो पेपर डिस्कस कर रहे हैं वो बिहार का सिविल जज का 2020 का पेपर है, लॉ का। तो हम ये लॉ का पेपर जो है डिस्कस करने जा रहे हैं और हमारे चैनल को ज़रूर आप सब्सक्राइब ज़रूर कर लें। और इसके साथ साथ आपको डिस्क्रिप्शन सेक्शन में लिंक मिल जाएगा टेलीग्राम का। तो अगर आप कोई भी बात मुझसे कहना चाहते हैं या कोई भी कम्युनिकेशन आप करना चाहते हैं तो आप उस टेलीग्राम चैनल पर जा करके वहाँ पर मुझे मैसेज कर सकते हैं। तो चलिए शुरू करते हैं पहले क्वेश्चन से। क्वेश्चन नंबर 1, हु प्रपोज द प्रीएम्बल बिफोर द ड्राफ्टिंग कमेटी ऑफ द कॉन्स्टिट्यूशन? ऑप्शन ए जवाहरलाल नेहरू, ऑप्शन बी BR अम्बेडकर, ऑप्शन सी BN राव एंड ऑप्शन डी महात्मा गांधी। करेक्ट आंसर यहाँ पर है जवाहरलाल नेहरू। क्वेश्चन नंबर 2, when was the first meeting of the Constitution Assembly held? ऑप्शन ए 8th दिसंबर, ऑप्शन बी 9th दिसंबर, ऑप्शन सी 10th दिसंबर एंड ऑप्शन डी 12th दिसंबर। करेक्ट आंसर यहाँ पर जो है 9th दिसंबर है। पहली जो मीटिंग थी कॉन्स्टिट्यूशन असेंबली की वो हेल्ड हुई थी 9th दिसंबर को। उसके बाद आता है क्वेश्चन नंबर 3। क्वेश्चन नंबर 3, द कॉन्स्टिट्यूशन वॉज ओवर ऑन द टास्क ऑफ मेकिंग दी ए 26 नवंबर 1949, बी 26 जनवरी 1950, सी 15 अगस्त 1947 एंड डी 25 नवंबर 1949। करेक्ट आंसर यहाँ पे थर्ड का है ऑप्शन ए, यानी कि 26 नवंबर 1949। नाउ लेट अस प्रोसीड टू क्वेश्चन नंबर 4। द कॉन्सेप्ट ऑफ फंडामेंटल राइट्स वाज बोरोड फ्रॉम द ब्रिटिश कॉन्स्टिट्यूशन, यूएस कॉन्स्टिट्यूशन, ऑस्ट्रेलियन कॉन्स्टिट्यूशन, कैनेडियन कॉन्स्टिट्यूशन। करेक्ट आंसर यहाँ पर क्या है? करेक्ट आंसर यहाँ पर है बी, यूएस कॉन्स्टिट्यूशन। यूएस कॉन्स्टिट्यूशन से जो कॉन्सेप्ट है फंडामेंटल राइट्स का वो बोरो किया गया था। आइए बढ़ते हैं क्वेश्चन नंबर 5 की तरफ। क्वेश्चन नंबर 5, व्हाट इज द एम ऑफ DPSP इन द कॉन्स्टिट्यूशन? डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसीज का क्या एम है कॉन्स्टिट्यूशन में? ऑप्शन ए टू एस्टैब्लिश अ वेलफेयर स्टेट, ऑप्शन बी टू प्रमोट कम्युनलिज्म, ऑप्शन सी टू एस्टैब्लिश इकोनॉमिक स्टेट एंड ऑप्शन डी टू मेंटेन लॉ एंड ऑर्डर। यहां पर ऑब्वियसली आंसर ए ही सही है, टू एस्टैब्लिश वेलफेयर स्टेट। क्वेश्चन नंबर 6, विच कमेटी इज रिलेटेड टू पंचायती राज इंस्टीट्यूशन? ऑप्शन ए मुधोलकर कमेटी, ऑप्शन बी बलवंत राय मेहता कमेटी, ऑप्शन सी मलिमत कमेटी एंड ऑप्शन डी खुल्लर कमेटी। करेक्ट आंसर यहाँ पर है ऑप्शन बी बलवंत राय मेहता कमेटी। ये बहुत इंपॉर्टेंट है और पंचायती राज इंस्टीट्यूशन से अगर कोई भी क्वेश्चन आता है तो वहाँ पर बलवंत राय मेहता कमेटी का क्वेश्चन अक्सर पूछा गया है, तो इस क्वेश्चन को आप जरूर ध्यान से पढ़ लीजिएगा। क्वेश्चन नंबर 7, विच कॉन्स्टिट्यूशनल अमेंडमेंट इज नोन एज मिनी कॉन्स्टिट्यूशन? एक बहुत ही आसान क्वेश्चन है, आप सभी को इसका आंसर पता होगा। 42nd अमेंडमेंट एक्ट को बोलते हैं मिनी कॉन्स्टिट्यूशन। क्वेश्चन नंबर 8, हु हैज सर्व्ड इंडियाज 12th प्रेसिडेंट? भारत का 12वां प्रेसिडेंट कौन था? श्री रामनाथ कोविंद जी, APJ अब्दुल कलाम, प्रतिभा पाटिल, प्रणब मुखर्जी। करेक्ट आंसर यहाँ पर क्या है? करेक्ट आंसर है ऑप्शन सी, यानी कि प्रतिभा पाटिल। प्रतिभा पाटिल सर्व्ड इंडियाज 12th प्रेसिडेंट। क्वेश्चन नंबर 9, हु अपॉइंट्स द एडवोकेट जनरल ऑफ द स्टेट? एडवोकेट जनरल ऑफ द स्टेट कौन अपॉइंट करता है? ऑप्शन ए द प्रेसिडेंट, ऑप्शन बी द प्राइम मिनिस्टर, ऑप्शन सी द गवर्नर एंड ऑप्शन डी द चीफ जस्टिस, द चीफ मिनिस्टर। हियर इन क्वेश्चन नंबर 9 द करेक्ट आंसर इज ऑप्शन सी, गवर्नर। एडवोकेट जनरल अगर आप आर्टिकल 165 पढ़ेंगे तो उसमें विस्तार से समझाया गया है, गवर्नर इसे अपॉइंट करते हैं स्टेट में। क्वेश्चन नंबर 10, द पोस्ट ऑफ डेप्यूटी प्राइम मिनिस्टर is constitutional, non-constitutional, judicial, none of the above। यहाँ पर करेक्ट आंसर है ऑप्शन बी, दैट इज नॉन कॉन्स्टिट्यूशनल। कॉन्स्टिट्यूशन में डिप्टी प्राइम मिनिस्टर की पोस्ट नहीं दी गई है, इसलिए ये आंसर जो है बी सही है। क्वेश्चन नंबर 11, विच पार्ट ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया डील्स विद द फाइनेंस, प्रॉपर्टी, कॉन्ट्रैक्ट एंड सूट्स? पार्ट 12, पार्ट 13, पार्ट 17 एंड पार्ट 19। यहाँ पे करेक्ट आंसर है ऑप्शन ए, दैट इज पार्ट 12। Question number 12. Which article of the Indian Constitution talks about the audit of accounts of the cooperative societies? Option A, Article 243ZA, option B, Article 243ZE, option C, Article 243ZK and option D, Article 243ZM। यहाँ पर करेक्ट आंसर है ऑप्शन डी, दैट इज आर्टिकल 243ZM। ये बात करता है ऑडिट ऑफ अकाउंट्स ऑफ कोऑपरेटिव सोसाइटीज की। क्वेश्चन नंबर 13, आर्टिकल 279 ऑफ द इंडियन कॉन्स्टिट्यूशन डिफाइंस ए टैक्सेस ऑन प्रोफेशन, कैलकुलेशन ऑफ नेट प्रोसीड्स, फाइनेंस कमीशन, ग्रांट्स फ्रॉम द यूनियन टू सर्टेन स्टेट्स। यहाँ पर करेक्ट आंसर है ऑप्शन बी, दैट इज कैलकुलेशन ऑफ नेट प्रोसीड्स। क्वेश्चन नंबर 14, in which of the following cases Justice Hidayatullah held the preamble is very soul of the constitution, eternal and unalterable? Option R, SR Bommai case, option B गोलकनाथ case, option C case of Nanda Bharti case and option D Minerva Mills case। यहाँ पर करेक्ट आंसर है ऑप्शन बी, दैट इज गोलकनाथ केस। Question number 15, who among the following has said that the preamble is an epitome of the basic feature of the constitution? ऑप्शन ए जस्टिस ओजेंद्र गढ़कर, ऑप्शन बी जस्टिस सुब्बा राव, ऑप्शन सी जस्टिस मुधोलकर एंड ऑप्शन डी जस्टिस सीकरी। करेक्ट आंसर यहां पर है ऑप्शन सी, दैट इज जस्टिस मुधोलकर। क्वेश्चन नंबर 16, द कॉन्सेप्ट ऑफ इक्वल प्रोटेक्शन ऑफ लॉज enshrined under आर्टिकल 14 ऑफ द इंडियन कॉन्स्टिट्यूशन फाइंड इट्स रूट्स फ्रॉम द ब्रिटिश कॉन्स्टिट्यूशन, अमेरिकन कॉन्स्टिट्यूशन, जर्मन कॉन्स्टिट्यूशन, ऑस्ट्रेलियन कॉन्स्टिट्यूशन। करेक्ट आंसर यहां पर है ऑप्शन बी, अमेरिकन कॉन्स्टिट्यूशन। Question number 17, in which of the following cases Supreme Court held that equality clause cannot be applied to legitimize an illegal action? किस केस में सुप्रीम कोर्ट ने कहा था कि इक्वालिटी क्लॉज जो है उसको लेजिटिमाइज नहीं किया जा सकता किसी भी इलीगल एक्शन के लिए? ऑप्शंस आर यूपी स्टेट शुगर कॉर्पोरेशन लिमिटेड वर्सेस संत राज सिंह, ऑप्शन बी विशाल प्रॉपर्टीज प्राइवेट लिमिटेड वर्सेस स्टेट ऑफ यूपी एंड ऑप्शन सी एकता शक्ति फाउंडेशन वर्सेस गवर्नमेंट ऑफ एनसीटी ऑफ दिल्ली एंड ऑप्शन डी भगवान दास वर्सेस पंजाब स्टेट इलेक्ट्रिसिटी बोर्ड। यहाँ पर क्वेश्चन नंबर 17 में करेक्ट आंसर है ऑप्शन सी, दैट इज एकता शक्ति फाउंडेशन वर्सेस गवर्नमेंट ऑफ एनसीटी ऑफ दिल्ली। क्वेश्चन नंबर 18 पर पहुंचने से पहले आपको एक थोड़ा सा आपसे एक रिक्वेस्ट है कि अगर आप लोग इंस्टाग्राम पर हैं तो प्लीज़ इंस्टाग्राम पे मयंक लोहालिक के जो पेज है उसको प्लीज़ फॉलो कर लें, और अगर आप वहाँ से भी मुझसे कोई कम्युनिकेशन करना चाहते हैं तो आप मुझे इंस्टा पे डीएम कर सकते हैं। तो एक छोटी सी इन्फॉर्मेशन थी, बाद में कहीं भूल ना जाऊँ इसलिए मैं बता रहा हूँ, क्योंकि मैं अपना प्रमोशन सेल्फ प्रमोशन बहुत कम कर पाता हूँ, इसी वजह से मेरे सब्सक्राइबर्स उतनी जल्दी नहीं बढ़ते, क्योंकि सेल्फ प्रमोशन में कहीं ना कहीं मैं पीछे रह जाता हूँ। तो ये बातें मुझे कई लोग बोलते हैं बोलने के लिए, इसीलिए मैं बोल रहा हूँ कि अगर आप लोग इंस्टाग्राम पे हैं, जो कि मुझे लगता है बहुत सारे लोग इंस्टाग्राम पे हैं ही, तो प्लीज़ इंस्टाग्राम पे आप मुझे फॉलो कर लीजिए, और अगर कोई बात है तो आप मुझे डीएम भी कर सकते हैं। क्वेश्चन नंबर 18, promotion of international peace and security comes under the purview of which article of the Indian Constitution? Options are article 46, article 49, article 51, article 53। यहाँ पर करेक्ट आंसर है ऑप्शन सी, दैट इज आर्टिकल 51। Question number 19, as per article 77 of the Indian Constitution, actions of the government of all executive India shall be expressed to be taken in the name of the Government of India, Union of India, President, Prime Minister। करेक्ट आंसर यहाँ पर है ऑप्शन सी, दैट इज प्रेसिडेंट। आर्टिकल 77 ऑफ द इंडियन कॉन्स्टिट्यूशन, एक्शंस ऑफ द गवर्नमेंट ऑफ ऑल एग्जीक्यूटिव ऑफ इंडिया शैल बी एक्सप्रेस्ड बी टेकन इन द नेम ऑफ द प्रेसिडेंट। क्वेश्चन नंबर 20, द सुप्रीम कोर्ट ऑफ इंडिया डिक्लेयर्ड विच कॉन्स्टिट्यूशनल अमेंडमेंट एज unconstitutional? Option A 97th amendment, option B 98th, option C 99th and option D 91st amendment। यहाँ पर करेक्ट आंसर है ऑप्शन सी, दैट इज 99th amendment जो है उसको सुप्रीम कोर्ट ऑफ इंडिया ने डिक्लेयर किया था अनकॉन्स्टिट्यूशनल। क्वेश्चन नंबर 21, व्हाट इज द मिनिमम नंबर ऑफ जजेस who are to sit for the purpose of deciding any case involving substantial question of law as to the interpretation of constitution? Option A 3 judges bench, option B 5 judges bench, option C 7 judges bench and option D 9 judges bench। यहाँ पर करेक्ट आंसर है ऑप्शन बी, दैट इज 5 judges bench। 5 judges bench जो है वो करेक्ट आंसर है। क्वेश्चन नंबर 22, द कंट्रोलर एंड ऑडिटर जनरल ऑफ इंडिया शैल सबमिट हिज रिपोर्ट रिलेटिंग टू द अकाउंट्स ऑफ द यूनियन टू द ऑप्शन ए पब्लिक अकाउंट्स कमेटी, पार्लियामेंट, ऑप्शन सी प्रेसिडेंट एंड ऑप्शन डी फाइनेंस मिनिस्टर। करेक्ट आंसर यहाँ पर है ऑप्शन सी, दैट इज प्रेसिडेंट। Question number 23, which one among the following has exclusive powers to expand all India services? All India services को expand करने की exclusive power किसके पास है according to the Constitution of India? Options are the Parliament, option B the Lok Sabha only, option C the Rajya Sabha only and option D the President। Correct answer यहाँ पर है option C, that is the Rajya Sabha only। Question number 24, according to the Indian Constitution, which one of the following is the language of the Union? Option A Hindi in Bundeli script, Hindi in Devanagari script, Hindi and English both, only Hindi not English। यहाँ पर क्वेश्चन नंबर 24 में करेक्ट आंसर है ऑप्शन बी, दैट इज हिंदी इन देवनागरी स्क्रिप्ट। Question number 25. Which article of the Indian Constitution saves the judgment of the Privy Council? Option A, Article 295, option B, Article 301, option C, Article 393 and option D, Article 395. Correct answer यहाँ पर है option D, that is Article 395. Question number 26. Who was the chairman of the first commission on review of the Indian Constitution? ये एक important question है. Option A, Justice Venkatachalaya, option B, Justice Hidayatullah, option C, Justice A.M. Ahmadi and option D, Justice K.G. Balakrishnan. Correct answer यहाँ पर है option A, that is Justice Venkatachalaya. Question number 27. Which one of the following writs is also known as a judicial remedy? Option R, habeas corpus, option B, mandamus, option C, quo warranto and option D, certiorari. Correct answer यहाँ पर है option B, that is mandamus. Mandamus is also known as judicial remedy. Question number 28. Every proclamation issued under Article 352 shall be laid before each house of the parliament, laid before the Lok Sabha, decided by the Prime Minister and conveyed to the President and none of the above. Correct answer यहाँ पर है option A, that is laid before each house of the parliament. Question number 29. The Finance Commission consists of option A, 5 members, option B, 4 whole-time members, option C, a chairman and 4 members, option D, a chairman and 3 other members. यहाँ पर correct answer है option C, that is a chairman and 4 members. Question number 30. The composition of the UPSC, option A, has been laid down in the Constitution, option B is determined by the Parliament, option C is determined by the President and option D is determined by the Home Minister. Correct answer यहाँ पर है option C, that is determined by the President. Question number 31. Article 340 of the Indian Constitution deals with the Backward Classes Commission, Election Commission, UPSC, Finance Commission. Correct answer यहाँ पर है option A, that is Backward Classes Commission. Question number 32. According to which article of the Constitution of India the term district judge shall not include a tribunal judge? Options are Article 235, option B, Article 235 Clause A, option C, Article 235 Clause 236 Clause A and option D, Article 236 Clause B. यहाँ पर correct answer है option C, that is Article 236 Clause A. बढ़ते हैं क्वेश्चन नंबर 33 की तरफ. क्वेश्चन नंबर 33. Mainly on whose advice the president's rule is imposed in a state? Option A, the chief minister, option B, the governor, option C, the union cabinet and option D, on his own motion. यहाँ पर correct answer है option B, that is the governor. Question number 34. In which article the doctrine included? Option A, Article 13, Article 14, Article 21, Article 256. यहाँ पर करेक्ट आंसर है ऑप्शन सी, दैट इज आर्टिकल 21. ये क्वेश्चन अपने आप में कंप्लीट नहीं है, क्वेश्चन नंबर 34, लेकिन जो आंसर शीट थी उसके हिसाब से आर्टिकल 21 है. क्वेश्चन नंबर 35. द डॉक्ट्रिन ऑफ सेपरेशन ऑफ पावर्स वॉज सिस्टमैटिकली फॉर्मुलेटेड बाय प्लेटो, मोंटेस्क्यू, डाइसी, अरिस्टोटल. In question number 35, correct answer is option B, that is Montesquieu. The doctrine of separation of powers was systematically formulated by Montesquieu. Question number 36. The rule of law means option A, supremacy of the judiciary, option B, supremacy of the law, option C, equality before the law and option 4, supremacy of the parliament. Select the correct answer using the codes given below. Option A, 1 and 3, option B, 3 and 4, option C, 2 and 4 and option D, 2 and 3. In question number 36, correct answer will be option D, that is 2 and 3. The rule of law means supremacy of the law and equality before the law. Question number 37. क्वेश्चन 37 में हमको मैच करना है लिस्ट फर्स्ट और लिस्ट सेकंड को. तो अब्यूज ऑफ डिस्क्रिशन, यहां पर इसका सही मैच होगा लैक ऑफ पावर. ठीक. इक्वलिटी बिफोर लॉ, इसका सही मैच होगा रूल ऑफ लॉ. ठीक. डेलीगेटेड लेजिस्लेशन, इसका सही मैच है डेलीगेटेड लेजिस्लेशन का सबऑर्डिनेट लेजिस्लेशन. और सेपरेशन ऑफ पावर्स, ये लास्ट है, इसका है चेक एंड बैलेंस, ये है डी. तो इसके हिसाब से अगर हम कोड देखते हैं तो इसमें सही आंसर होगा ऑप्शन ए. Question number 38. Which one of the following statements is true? Option A, delegated legislation cannot have retrospective effect. Delegated legislation have retrospective effect if by act can authorized by statute. Option C, delegated legislation can have retrospective effect if not authorized by act or statute but have reasonable and rational justification. Option D, none of the above. Correct answer यहाँ पर है option B. Which one of the following statement is true? Second statement, that is option B, is true. Delegated legislation have retrospective effect if by act can authorize or by statute. Question number 39. The application of doctrine of vicarious liability seems to have been actuated crimes by a necessity of desirability. The justification is based on which of the following? Option A, public policy. Option B, failure to supervise. Option C, treated as unauthorized. And option D, strict liability. And question number 39, correct answer is option A, that is public policy. Question number 40. Administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. This definition of administrative law is given by option A, Ivor Jennings, option B, Garner, option C, K.C. Davis, and option D, Wade. करेक्ट आंसर यहाँ पर है ऑप्शन सी, दैट इज के.सी. डेविस. ये जो डेफिनेशन है ये दी है के.सी. डेविस ने. क्वेश्चन नंबर 41. द ऑथर ऑफ दयाबाग वॉज ऑप्शन ए विघ्नेश्वर, ऑप्शन बी जिमुतवाहना, ऑप्शन सी वशिष्ठ, ऑप्शन डी नारद. यहाँ पे करेक्ट आंसर है ऑप्शन बी, दैट इज जिमुतवाहना. Question number 42. Under which section of the Hindu Marriage Act 1955 a Hindu marriage may be declared as void? Option A, section 9, option B, section 10, option C, section 11, and option D, section 12. करेक्ट यहाँ पर आंसर है ऑप्शन सी, दैट इज सेक्शन 11. सेक्शन 11 ऑफ हिंदू मैरिज एक्ट में हिंदू मैरिज जो है वो वॉइड डिक्लेयर की जा सकती है. क्वेश्चन नंबर 43 में हम आगे बढ़ते हैं. सेक्शन 16 ऑफ द हिंदू मैरिज एक्ट 1955 डज नॉट कन्फर स्टेटस ऑफ लेजिटिमेसी टू चिल्ड्रन बॉर्न. ऑप्शन ए, आउट ऑफ अ वैलिड मैरिज. ऑप्शन बी, आउट ऑफ अ वॉइडेबल मैरिज. ऑप्शन सी, आउट ऑफ अ वॉइड मैरिज. एंड ऑप्शन डी, विदाउट मैरिज. यहाँ पर करेक्ट आंसर है ऑप्शन डी, दैट इज विदाउट मैरिज. क्वेश्चन नंबर 44. Under the Hindu Adoption and Maintenance Act 1956, a child to be adopted should not have, in the absence of a valid custom, completed the age of 8 years, 10 years, 12 years, 15 years. Question number 44 में correct answer is option D, that is 15 years. Question number 45. After the Hindu Succession Amendment Act 2005, Mitakshara Hindu Coparcenary does not include whom as its member? Option is son, option B, married daughter, option C, adopted son, and option D, daughter-in-law. Here in question number 45, correct answer is option D, that is daughter-in-law. Daughter-in-law does not include as a member. Question number 46. A Hindu male is survived by an adopted son, an after-born natural son, and his married daughter. His self-acquired property shall devolve upon option A, all the three equally, option B, only to the two sons, option C, only to the natural and to the daughter, and option D, only to the natural son. In question number 46, correct answer is option A, that is all the three equally. Question number 47. A Hindu female is survived by a stepson, a married daughter, and an illegitimate son. Her property shall devolve upon option A, all the three equally, option B, only to the married daughter, option C, her daughter and the stepson, and option D, her daughter and her illegitimate son. यहाँ पर correct answer is option D, that is her daughter and her illegitimate son. Now let us proceed to question number 48. On partition of a Hindu coparcenary property, the person not entitled for a share is an adopted son, a married daughter, an illegitimate son, widow of a coparcener. यहाँ पर correct answer है option C, that is an illegitimate son. Question number 49. Stridhan does not include option A, the chastity of a female, option B, presents given to her, property purchased by her, property inherited by her. यहाँ पर correct answer है option A. Stridhan does not include the chastity of a female. Question number 50. The legal position of a Hindu idol is of a option A, Hindu major male, Hindu major female, Mahant, Hindu minor. Here in question number 50, correct answer is option D, that is Hindu minor. हम अब 50 क्वेश्चंस कंप्लीट कर चुके हैं. टोटल यहाँ पर है 150 क्वेश्चंस. तो अभी हमारा प्लान है पूरा पेपर कंप्लीट करने का. तो आप लोग जो 50 क्वेश्चंस तक कंप्लीट कर चुके हैं स्क्रीन पर बने रहिए, क्योंकि अभी और क्वेश्चंस आने वाले हैं और मन लगाकर इन सारे क्वेश्चंस को हम सॉल्व करते हैं. लेट अस स्टार्ट फ्रॉम क्वेश्चन नंबर 51. अमंग द सोर्सेज ऑफ मुस्लिम लॉ द फोरमोस्ट इज सुन्ना, इज्म, कियास, कुरान. Correct answer here is option D, that is Quran. Question number 52. The Sunni law does not recognize option A, Shahi, valid marriage, मुत्ता, टेम्परेरी मैरिज, फासिद, इरेगुलर मैरिज, बातिल, वॉइड मैरिज। सुन्नी लॉ क्या रिकॉग्नाइज नहीं करता है इनमें से? तो मुत्ता मैरिज जो है उसे सुन्नी लॉ रिकॉग्नाइज नहीं करता है। ऑप्शन बी करेक्ट आंसर है। ऑप्शन 3, अ मुस्लिम मैरिज विदाउट डार इज वैलिड, वॉइड, इरेगुलर, वॉइडेबल। करेक्ट आंसर यहाँ पर है ऑप्शन ए, दैट इज वैलिड। क्वेश्चन नंबर 54, अ गिफ्ट इन फेवर ऑफ एन अनबॉर्न चाइल्ड इज वैलिड, इरेगुलर, वॉइडेबल, वॉइड। करेक्ट आंसर यहाँ पर है ऑप्शन डी, दैट इज वॉइड। A gift in favor of an unborn child is void. Question number 55. A bequest may be made to a child in the womb provided it is born from the date of the will within 6 months, 8 months, 9 months, 10 months. Correct answer यहाँ पर है option A, that is 6 months. Question number 56. A waqf cannot be created for option A, celebrating the birth of Ali Murtaza, option B, construction of a church, option C, maintenance of Khanaka, option D, the construction of a bridge. Here in question number 56 correct answer is option B. वक्फ जो है वो चर्च बना, कंस्ट्रक्शन ऑफ चर्च के लिए नहीं क्रिएट किया जा सकता, जो कि लॉजिकल सीम कर रहा है। Question number 57. The difference of ages between the acknowledger and the acknowledged child must be at least option A 8 years, option B 10 years, option C 11 years and option D 12 years. यहाँ पर करेक्ट आंसर है ऑप्शन सी में D 12 years। परसेंटेज के साइन को इग्नोर कर दो। क्वेश्चन नंबर 58. द कस्टडी ऑफ ए माइनर वाइफ शैल बी विद हर हस्बैंड, फादर इन लॉ, ऑप्शन सी मदर एंड ऑप्शन डी फादर इन लॉ। यहाँ पे करेक्ट आंसर है ऑप्शन सी, दैट इज मदर। द कस्टडी ऑफ ए माइनर वाइफ शैल बी विद हर मदर। Question number 59. An illegitimate Shia Mohammedan dies intestate. His property will be inherited by option A, his mother, his father, his brother, none of them. Correct answer यहाँ पर is option D, that is none of them. Question number 60. A Shia Muslim already having 4 wives has contracted a 5th marriage. This 5th marriage is valid, voidable, void, irregular. Correct answer यहाँ पर है option C, that is void. क्वेश्चन नंबर 61. मैच लिस्ट फर्स्ट एंड लिस्ट सेकंड। हमें यहाँ पर लिस्ट फर्स्ट और लिस्ट सेकंड को मैच करना है। चलिए, और लिस्ट फर्स्ट में पहला है फीडिंग द ग्रांट बाय स्टॉपल। इसका जो करेक्ट आंसर है सेक्शन 43। ओके। डॉक्ट्रिन ऑफ सबरोगेशन, इसका जो करेक्ट मैच है सेक्शन 92। उसके बाद है डॉक्ट्रिन ऑफ एक्यूमुलेशन। डॉक्ट्रिन ऑफ एक्यूमुलेशन का करेक्ट मैच है सेक्शन 17 और रूल अगेंस्ट परपेचुइटी दिया गया है सेक्शन 14 टीपीए में। तो ये हमारे हो गए टीपीए के जो इंपॉर्टेंट डॉक्ट्रिन्स हैं उनका मैच, और इसके हिसाब से जो आंसर होना चाहिए कोड में वो होगा ऑप्शन ए। क्वेश्चन नंबर 62. द प्रोविजन रिगार्डिंग द डॉक्ट्रिन ऑफ सब्सटीट्यूटेड सिक्योरिटी इज कंटेन्ड under which of the following section of the Transfer Property Act? Option A, section 74, option B, section 75, option C, section 73 and option D, section 72. Correct answer यहाँ पर है option C, that is section 73. Question number 63. Consider the following statements regarding the distinction between lease and license. लीज एंड लाइसेंस में जो डिस्टिंक्शन है उसके बारे में ये स्टेटमेंट्स हैं। फर्स्ट, अ लीज कैन बी असाइंड बट लाइसेंस कैन नॉट बी असाइंड। सेकंड, बोथ लीज एंड लाइसेंस होल्डर्स कैन सू ट्रेसपासर्स ऑन हिज ओन नेम। थर्ड, a lease is a transfer of an interest in land whereas a license does not create any interest in land. Four, a lease cannot be revoked until the end of the term but a license subject to certain exceptions can be revoked. तो यहाँ पर करेक्ट आंसर जो है कौन सा है? यहाँ करेक्ट आंसर है ऑप्शन ए, 2, 3 and 4। 2, 3 and 4 स्टेटमेंट जो है वो सही है और जो फर्स्ट स्टेटमेंट है वो गलत है। क्वेश्चन नंबर 64. राइटिंग एंड रजिस्ट्रेशन आर नॉट रिक्वायर्ड इन विच वन ऑफ द फॉलोइंग मॉर्गेजेस? ऑप्शन ए, यूजफ्रक्शनरी मॉर्गेजेस, ऑप्शन बी, मॉर्गेजेस बाय डिपॉजिट ऑफ टाइटल डीड्स, ऑप्शन सी, सिंपल मॉर्गेज एंड ऑप्शन डी, इंग्लिश मॉर्गेज। करेक्ट आंसर यहाँ पर है ऑप्शन बी, दैट इज मॉर्गेज बाय डिपॉजिट ऑफ टाइटल डीड्स। क्वेश्चन नंबर 65. Which one of the following does not constitute exception to the rule against perpetuity? Option A, a fund is bequeathed to the next 7 generation. Option B, where property is transferred for the benefit of public. Option C, it does not apply to vested interest. And option D, a lease with a covenant for renewal. यहाँ पर correct answer है option A, that is a fund is bequeathed for the next 7 generations. Question number 66. The literary meaning of lis pendens is Option A, a previous decision bars the subsequent filing of the suit. Option B, a suit under consideration of any court of law. And C, an exception to the doctrine of res judicata. And option D, none of the above. यहाँ पर करेक्ट आंसर है क्वेश्चन नंबर 66 में ऑप्शन बी, दैट इज अ सूट अंडर कंसिडरेशन ऑफ एनी कोर्ट ऑफ लॉ. Question number 67. Which one of the following sections of the Transfer Property Act provides for the competency to the transfer of any immovable property? Options are section 17, section 16, section 10, section 7. यहाँ पे करेक्ट आंसर है ऑप्शन डी, दैट इज सेक्शन 7. Question number 68. Under which section of the Transfer Property Act there is a restriction for accumulation of property beyond a certain period? Options are section 17, section 14, section 20, section 25. करेक्ट आंसर यहाँ पर है ऑप्शन ए, दैट इज सेक्शन 17. Question number 69. The principle of marshalling and contribution is a principle under the Law of Transfer Property Act which relates to the matter of option A, deposit, option B, lease, option C, security, and option D, gift. Correct answer here is option C, that is security. Question number 70. Where a gift is made of a property which is not in existence, which one of the following sections of the Transfer Property Act declares it void? Option A, section 124, option B, section 125, option C, section 126, and option D, section 127. Correct answer यहाँ पर है option A, that is section 124. Question number 71. The primary source of equity is option A, written law, option B, conscience, option C, custom, and option D, judicial decisions. Correct answer यहाँ पर option B, conscience है. Option B is the correct answer. Question number 72. The statutory recognition of the principles of equity is not found in the option A, Indian Contract Act 1872, Specific Relief Act 1877, Sales of Goods Act 1930, Indian Succession Act 1925. Correct answer यहाँ पर है option D, that is Indian Succession Act 1925. वो फाउंड नहीं होता इक्विटी के प्रिंसिपल्स में. क्वेश्चन नंबर 73. इक्विटी हैज थ्री-फोल्ड जुरिसडिक्शन, एक्सक्लूसिव, करंट एंड ऑक्सिलरी. दिस इज सेड बाय द ऑप्शन ए, मेटलैंड, ऑप्शन बी, स्टोरी, ऑप्शन सी, ऑस्टिन, एंड ऑप्शन डी, रॉस्को पॉन्ड. करेक्ट आंसर यहां पर है ऑप्शन बी, दैट इज स्टोरी. क्वेश्चन नंबर 74. इंग्लिश रूल्स ऑफ इक्विटी, option A, have been substantially incorporated by the Indian legislatures. B, have not at all been incorporated by the Indian legislatures. C, have been wholly incorporated by the Indian legislatures. And D, have been partially incorporated by the Indian legislature. तो क्वेश्चन नंबर 74 में करेक्ट आंसर है ऑप्शन A, that is English rules of equity have been substantially incorporated by the Indian legislature. Question number 75. A trust is extinguished in which of the following conditions? Option A, when the trust being revocable is expressly revoked. B, when its purpose is completely fulfilled. C, when its purpose becomes unlawful. And option D, all of the above. Correct answer यहाँ पर है option D, that is all of the above. Question number 76. Breach of trust has been defined under which section of the Indian Trust Act 1882? Section 2, Section 3, Section 6, Section 10. Correct answer यहाँ पर है option B, that is Section 3. Question number 77. Who among the following cannot create a trust? Option A, a juristic person, option B, a minor, option C, an advocate, and option D, a person of 21 years of age. तो correct answer यहाँ पर है option B, that is a minor. Question number 78. Recovery of a specific immovable property may be made under section 5 of the Specific Relief Act according to the option A, Law of Code of Civil Procedure, Law of Contract, Law of Transfer Property Act, Law of Sale of Goods Act. करेक्ट आंसर यहाँ पर है ऑप्शन ए, दैट इज लॉ ऑफ कोड ऑफ सिविल प्रोसीजर. क्वेश्चन नंबर 79. The general principle on which the perpetual injunctions could be granted is contained in option A, section 39, option B, section 36, option C, section 38, and option D, section 40. करेक्ट आंसर यहाँ पर है ऑप्शन सी, दैट इज सेक्शन 38. क्वेश्चन नंबर 80. The relief by way of mandatory injunction is option A, discretionary, option B, prohibitory, option C, mandatory, and option D, none of the above. Correct answer यहाँ पर है option A, that is discretionary. Question number 81. Contract without consideration will be voidable, void, illegal, none of the above. Correct answer यहाँ पर है option B, that is void. Contract without consideration is void. Question number 82. The age of majority for a contract is 18 years, 21 years, 16 years, 18 years for girls and 21 for boys. यहाँ पर क्वेश्चन नंबर 82 में करेक्ट आंसर है ऑप्शन ए, दैट इज 18 years. The age of majority for contract is 18 years. Question number 83. A gets an offer to give 1000 to whoever finds his lost dog. This is option A, a specific offer, option B, a general offer, option C, not certain, option D, an amount to acceptance. यहाँ पर correct answer है option B, that is, it is a general offer. Question number 84. When the damage cannot be assessed, the party may be awarded by the court. Option A, actual damages, liquidated damages, exemplary damages, nominal damages. Correct answer यहाँ पर है option D, that is nominal damages. Question number 85. Non-S factor means executed in document ignorance, document executed under coercion, document executed under undue influence, document executed outside India. In question number 85, correct answer is option A, that is document ignorance. Question number 86. A contract not frustrated by, option A, commercial impossibility, option B, imposition of government restrictions, option C, destruction of subject matter of contract, and option D, all of the above. Correct answer यहाँ पर है option A, that is commercial impossibility. Question number 87. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other thereto. Option A is a void contract, option B is an illegal contract, option C is a voidable contract, option D is an unenforceable agreement. In question number 87, correct answer is option C, that is a voidable contract. Question number 88. Which one of the following is a case on promissory estoppel? इनमें से कौन सा promissory estoppel का केस है? केदारनाथ वर्सेस गौरी मोहम्मद, दिल्ली क्लॉथ एंड जनरल मिल्स लिमिटेड वर्सेस यूनियन ऑफ इंडिया. यहाँ पर ऑप्शन सी सही आंसर है. दोनों ही केसेस जो है वो promissory estoppel से रिलेटेड है. क्वेश्चन नंबर 89. Which one of the following statement is correct? The communication of acceptance is complete against the acceptor. Option A, when it comes to the knowledge of the acceptor. Option B, when it comes to the knowledge of the proposer. Option C, when it comes to the knowledge of the acceptor and proposer both. And option D, when it comes to the knowledge of the third party. यहाँ पर in question number 89 correct answer is option B, when it comes to the knowledge of the proposer. Question number 90. Which one of the following is not correctly matched? इनमें से correctly matched कौन से नहीं है? Question, चिक्कम अमीराजू versus चिक्कम श्रीशम्मा. B, liquidated damages का Dunlop Pneumatic Tire Limited versus New Garage and Motor Company Limited. C, impossibility of performance Alopi Prasad and Sons versus Union of India. And public policy Hadley versus Baxendale. यहाँ पर हमें बताना है कि कौन सा करेक्ट मैच नहीं है. तो 90 में जो करेक्ट आंसर है नॉट करेक्टली मैच है वो ऑप्शन 9 है. पब्लिक पॉलिसी जो है वो सही मैच नहीं है. क्वेश्चन नंबर 91. द इंडियन कॉन्ट्रैक्ट अमेंडमेंट एक्ट 1997 हैज अमेंडेड. Option A, Section 26 of Indian Contract Act, Section 27, Section 28, Section 75. Correct answer here is option C, that is Section 28. 1997 में Section 28 of the Indian Contract Act was amended. Question number 92. The change of the nature of obligation in a contract is known as rescission, novation, renovation, alteration. Correct answer यहाँ पर है novation. अगर कॉन्ट्रैक्ट के नेचर में चेंज आता है तो वो नोवेशन कहा जाता है. क्वेश्चन नंबर 93. अंडर सेक्शन 68 ऑफ द इंडियन कॉन्ट्रैक्ट एक्ट, ऑप्शन ए, द माइनर इज पर्सनली लायबल. ऑप्शन बी, ओनली माइनर्स प्रॉपर्टी इज लायबल. ऑप्शन सी, माइनर पर्सनली एंड हिज प्रॉपर्टी बोथ आर लायबल. एंड ऑप्शन डी, नन ऑफ द अबव. हियर करेक्ट आंसर इज ऑप्शन बी, दैट इज ओनली माइनर्स प्रॉपर्टी इज लायबल. Question number 94. Continuing guarantee has been defined under option A, Section 124 of the Indian Contract Act, Section 129 of the Indian Contract Act, Section 146 of the Indian Contract Act, and Section 148 of the Indian Contract Act. Correct answer यहाँ पर है option B, that is Section 129 of the Indian Contract Act. Question number 95. An agreement of wager is option A, voidable, option B, unlawful, option C, void, and option D, void and unlawful. Correct answer यहाँ पर है option C, that is void. An agreement of wager is void. Question number 96. The propounder of pigeonhole theory of tort is option A, Winfield, option B, Salmon, option C, Austin, and option D, Clark. Correct answer यहाँ पर है option B, that is Salmon. Res ipsa liquator is related to option A, a rule of evidence, option B, weapon of offense, option C, defense of some factor which was beyond control of the person who caused injury, and option D, a dangerous weapon. Here correct answer is option A, obviously. Res ipsa liquator is a rule of evidence. Sorry. The rule of strict liability was propounded by Justice Blackburn, Lord Devlin, Lord Atkin, Justice Holt. Correct answer here is option A, that is Justice Blackburn. The rule of strict liability was propounded by Justice Blackburn. Question number 99. Quae facet per alium facet per se means option A, liability under the law of negligence, option B, liability for unauthorized act, option C, vicarious liability, and option D, strict liability. Correct answer here is vicarious liability. In question number 99, correct answer is vicarious liability. Quae facet per alium facet per se means vicarious liability. Option C is the correct answer. Question number 100. Who divides wrongs as private wrongs and public wrongs? Option A, Fraser. Option B, Sir F. Pollock. Option C, Justice Blackburn. And option D, Blackstone. Correct answer here is option D, that is Blackstone. Question number 101. Which one of the following is not a valid defense in tort? Option A, volenti non fit injuria vis major, scienti non fit injuria, consent. Correct answer here is option C, that is scienti non fit injuria. Question number 102. The maxim damnum sine injuria means option A, damage without infringement of legal right. Option B, damage without infringement of legal right. Option C, infringement of legal right without damage. And option D, all of the above. Here correct answer is option A, damage without infringement of legal right. ऑप्शन ए जो है वो सही आंसर है। आप लोगों से एक छोटी सी रिक्वेस्ट और थी कि ये जो आप देख रहे होंगे कि कई सारे जो पेजेस हैं वो बहुत अच्छे या साफ़ नहीं दिखाई दे रहे, जो या स्लाइड्स बना नहीं है मेरे पास, तो उसके लिए मैं माफ़ी चाहता हूँ क्योंकि स्लाइड्स बनाने का जो समय है वो मेरे पास बहुत कम है, लिमिटेड समय है, मुझे इसमें कई सारी चीज़ें देखनी होती हैं, तो इसको आप प्लीज़ इग्नोर करिएगा। बाकी जो क्वेश्चन और आंसर्स हैं उनको आप देखिए, अगर उसमें कोई कमी होती है तो वो प्लीज़ आप मुझे मेंशन करिएगा, उसमें मैं आपकी हेल्प ज़रूर कर सकता हूँ। लेकिन जो यहाँ पर क्वालिटी दिखाई दे रही है या स्क्रीन रिकॉर्ड करके दिखा रहा हूँ, मैं स्लाइड्स नहीं बना रहा हूँ, तो वो बस मैं अपना टाइम बचाने के लिए ऐसा कर रहा हूँ। करने को मैं भी स्लाइड्स बना सकता हूँ और वो सारी चीज़ें कर सकता हूँ जो किसी एक चैनल पर आपको मिलती हैं, लेकिन क्योंकि उससे मेरे भी टाइम की बचत है, मेरा काम जल्दी हो जाता है कंपैरेटिवली। अगर मैं स्लाइड्स बनाता हूँ तो मुझे एक दिन तो स्लाइड्स बनाने में ही लग जाएगा, और फिर अगर मैं इन सारे क्वेश्चंस को लिखूँ या किसी और से लिखवाऊँ तो मुझे फिर वो क्रॉस चेक करना पड़ेगा, प्रूफ रीडिंग करनी पड़ेगी। तो इन सारी चीज़ों से बचने के लिए मैं सिर्फ स्कैन करके या क्वेश्चंस को ढूंढ करके आपके सामने लेके आता हूँ। तो प्लीज़ आप इसको इग्नोर करिएगा और आप चैनल को ज़रूर सब्सक्राइब करिएगा। चलिए बढ़ते हैं क्वेश्चन नंबर 103 की तरफ। The duty under the law of tort is option A, towards general individuals only, towards world at large, towards a specific individual only, none of the above. Correct answer यहाँ पर है option B, that is towards world at large. Question number 104. The principle of ubi jus ibi remedium was recognized in option A, Ashby versus White, option B, Rallance versus Fletcher, and option D, Plassley versus Freeman, option D, Lumi versus Gay. Here correct answer is Ashby versus White. The principle of ubi jus ibi remedium was recognized in Ashby versus White. Question number 105. The liability of independent tortonora is joint only, several only, both joint and several, neither joint nor several. Correct answer यहाँ पर है option B, that is several only. Question number 106. The rule of absolute liability implies strict liability only, state liability only, stricter than strict liability, none of the above. Question number 106, correct answer is option C, stricter than the strict liability implies absolute liability. Question number 107. To succeed in an action for the tort of negligence, what is required to be proved? Option A, damages sustained, option B, breach of duty owed to someone, option C, breach of duty owed to the plaintiff, and option D, none of the above. Correct answer here is option C, that is breach of duty owed to the plaintiff. Question number 108. No action lies for defamation if defamatory is written. Option A, in a telegram, in a notice board, in a postcard, in a letter but not posted and kept in own custody. यहाँ पर in question number 108 correct answer is option D. No action lies for defamation. अगर आपने कुछ लेटर लिखा है और आपकी कस्टडी में है, आप पब्लिश नहीं हुआ या किसी और ने नहीं पढ़ा, तो डिफेमेशन नहीं है, तो ये ऑप्शन डी करेक्ट आंसर है। क्वेश्चन नंबर 109. Which of the following is a defense of the tort of nuisance? Prescription, statutory authority, both A and B, none of the above. Here in question number 109, correct answer is option C, that is both A and B. Question number 110. The rule of de minimis non curate lex means that Trivial discrepancies must not be overlooked. Trivial discrepancies must be overlooked. Significant discrepancies must not be overlooked. Here in question number 110, correct answer is option B. Trivial discrepancies must be overlooked. इससे रिलेटेड आईपीसी का एक सेक्शन और है, अगर आपने वो पढ़ा है तो प्लीज़ आप कमेंट सेक्शन में बताइएगा कि डी मिनिमस नॉन क्यूरेट लेक्स, ये जो मैक्सिम है, इससे आईपीसी का कौन सा सेक्शन रिलेटेड है. Question number 111. What does the term future goods mean under section 2 clause 6 of the Sales of Goods Act 1930? Option A, uncertain goods. Option B, ascertained goods. Option C, specific goods under delivery. And option D, goods which are not in existence. Correct answer यहाँ पर है option D, that is goods which are not in existence. Question number 112. Answer to which of the following is not correct in making distinction between sale and agreement to sell? Statement A, a sale affects a transfer of the general property in the goods to the buyer, but the agreement to sell gives to either party a remedy for any default in fulfilling this part of agreement. B, a sales create jus in personam, whereas the agreement to sell create jus in rem. C, a sale, if the buyer fails to pay for the goods, the seller may sue for the price, but in agreement to sell, the seller can sue only for damages if the buyer fails to accept and pay for the goods. D, in sale, if goods are destroyed, the loss unless otherwise agreed falls on buyer. However, in agreement to sell, if goods destroyed, the loss unless otherwise agreed falls upon the seller. In question number 112, here the correct answer will be option B, because this is not correct in making distinction between sale and agreement to sell. Question number 113. The term caveat emptor means that the goods should be free from the defect. The ownership of the goods passes after the sale. Let the buyer be aware. Option C. And option D, the seller should disclose everything to the buyer. Here the caveat emptor means that let the buyer be aware. Option C here is the right answer. Question number 114. In which of the following statements, which one is incorrect when the sale is made by an auctioneer of goods and the issue is to pass a good title to the buyer? Option A, he is in possession of goods with the consent of the owner. B, the sale is made by him when acting in the ordinary course as an owner of the goods. C, the buyer acts in good faith. And D, the buyer has no notice at the time of the contract that seller has no authority to sell. Here in question number 114, correct answer is option B. The sale is made by him when acting in the ordinary course as owner of the goods. ये जो है वो incorrect है. Question number 115. A seller delivers to the buyers a larger quantity of goods than what was ordered. Which of the following is incorrect? The buyer has a right to reject the whole goods. Option A. The buyer has a right to accept the whole goods. Option C. And option C, the buyer has right to accept only the goods ordered and reject the rest. And option D, the buyer can retain the whole goods but make payment only for the goods ordered. Here in question number 115, it has been asked which will be the incorrect option. So option D here will be the incorrect option. Therefore, it is the answer. Therefore, it will be the answer. Question number 116. Now, let us proceed to question number 116. Which one of the following statement is not correct for the promissory note? A promissory note is an instrument in writing. B, it contains conditional undertaking signed by the maker. C, it is for the payment of certain sum of money only. And D, the payment is to a certain person or to a bearer of instrument. Here in this question, it has also again asked which of the following statement is not correct for promissory note. So while going through the options, option B, that is, it contains a conditional undertaking signed by the marker, is not correct. Therefore, it will be the right answer. Option B will be the right answer. Question number 117. Though a check resembles a bill of exchange in many respects, but it also a different instrument in other respects, point out which one of the following statement regarding the difference between the check and a bill of exchange is incorrect. Again, incorrect has been asked. Option A, a check does not require acceptance but a bill of exchange requires it. B, a check is not intended for the circulation but a bill of exchange is intended. C. A check is not entitled to some days of grace, but it in case of the bill of exchange. D. A check is dishonored by the non-acceptance, but this is not so in the case of bill of exchange. So as per the question, we have to answer the incorrect option. Here option D will be the incorrect, therefore it will be the right answer. So now let us proceed to question number 118. Which one of the following condition is not compatible with the essential elements of holders in due course? Option A, the holders must have taken the instrument for value. B, he must have obtained the instrument on the date of its maturity positively. C, the instrument must be complete and regular on its face. And D, he must have taken the instrument in good faith and without notice of any defect in the instrument. Here in question number 118, correct answer is option B. He must have obtained the instrument on the date of its maturity positively. Question number 19. Point out which one of the following statement is not correct regarding the assignment and negotiation of instrument. A. In assignment, there is a transfer of the right to receive the payment of debt, but it is not in the case of negotiation. B. The assignee is not liable for any defect in the title of his assigner, but a holder in the due course of negotiable instrument is liable for the defects in the title of the previous transferors. C. An assignment does not bind the debtor unless a notice of the assignment has been given to him, but information of the transfer of a negotiable instrument is to be given to the debtor. D. In assignment, there is no presumption in favor of assignee that he has given consideration. However, in case of holder in due course of negotiable instrument, he is presumed to have given consideration for the instrument. Here in question number 119, correct answer is, here in this question it has been asked which of the following is not correct. So option B is not correct, will be the right answer. Question number 120. Point out in which of the following circumstances banker is not justified in refusing the payment of a check. Option A, the date of the check falls after the date of the presentment. B, the balance of the customer's account is not sufficient to meet the check in account. C, the customer has countermanded the payment. D, the customer has become insolvent yet the bank has not received a notice of it. In question number 120, correct answer will be option D. The customer has become insolvent yet the bank has not received notice of it. Question number 121. The doctrine of indoor management has occupied a vital place in companies' functioning, but a number of decisions have made it subject to several exceptions. Point out which of the following is not an exception to the doctrine. Options are: the party affected by the irregularity had actual notice of it. B, the circumstances surrounding the contract are such suspicious which require inquiry. C, where authority has claimed of delegated powers beyond article of association. And D, where there is forgery to deal in. Here in question number 121, correct answer is option C, where authority has claimed delegated powers beyond articles of association. It is the right answer. Question number 122. Which of the following is a correct statement giving true relationship between articles of association and memorandum of association of company? Options are: articles of association being the bylaws of the general administration of the company are superior to the memorandum of association, and in case of any inconsistency they prevail. B, the articles of associations are subordinate to the memorandum of association, and in case of any inconsistency the articles must give way to the memorandum. C, there can be no comparison between the articles of association and memorandum of associations, both are equal footing. And D, all the above statements irrelevant as they detrimental to the growth of the company and such inconsistency happens between them. Here in question number 122, correct answer will be option B. The articles of association are subordinate to the memorandum of association, and in case of any inconsistency the articles must give way to the memorandum. Question number 123. When a company gets involved in an ultra-vires transaction, there are several remedies available against it. Point out which one of the following is not a correct statement. Options are: any director can get an injunction to restrain the company from proceeding with it. The directors will be personally liable to redress the company. C, the director in default will be personally liable to the third party for his loan. D, an ultra-vires contract cannot become intra-vires contract by reason of estoppel on ratification. Here in question number 123, we have to point out which for the following is not a correct statement. Here option A is not a correct statement. That's why it will be the right answer. Now let us proceed to question number 124. The Companies Act 2000 has provided limits on minimum or maximum number of directors. Which one of the following statement is not correct? Again, a not correct statement has been asked. Option A, a one-person company can have single director. A private company must have minimum of 2 directors. B, the public company must have a minimum of 3 directors. C, the cap maximum number of directors placed at 15 in private as well as in public companies. D, the number of directors can be increased beyond this limit by special resolution of the company with prior approval of the government. Here in question number 124, it has been asked which of the following is not correct. The option statement D here is the not correct. Question number 125. In case of the oppression, mismanagement in a company, an application may be made to a national company tribunal under the Companies Act 2000. Point out which one of the following statement is not correct in case of a company having share capital. Option A, 100 members or 1/10 of the total number of its members, whichever is less, may make application. B, any single member holding not less than 1/15 of the issued share capital of the company may make application. C, any single member holding not less than 1/10 of the issued share capital of the company may make application. Any group of the members holding at least 1/10 issued share capital of the company may make application. Here in question number 125, correct answer is option B. Here it has been asked which of the following is not correct in case of company having a share capital. B is not correct in related to having a share companies having a share capital. So option B will be the right answer in question number 125. Now let us proceed to question number 126. Find out the correct answer from the following statements for partnership. Option A, in overall analysis, it appears that every agency is based on mutual partnership. B, on comparing functions, every partner happens to be sleeping partner. C, there must be an agreement entered into by all the persons forming partnership. D, agreement must necessarily provide for sharing of profits as well as loss of the businesses. Here in question number 126, correct answer is option D. The agreement must necessarily provide for sharing of profits as well as the loss of business. Question number 127. Which one of the following statement is not correct for a dormant partner? Option A, a dormant partner is not interested in the business of the firm. A dormant partner is not liable for the firm's liability to outsiders. A dormant partner is entitled to share the profits of the firm. A dormant partner is neither active nor known to outsiders. Here correct answer is option B. A dormant partner is not liable for the firm's liability to outsiders. Question number 128. Out of the following statements, point out which one is not correct regarding the authority of the partner to act as agent of the firm implied. Options are option A, he has right to sell goods or chattels of the firm. B, he has right to receive payments of debts due to firm. C, he has right to make an equitable mortgage by depositing the title deeds belonging to firm. And D, he has right to acquire immovable property behalf of the firm. Here in question number 128, correct answer is, in this question it has been asked which of the following is not correct. So not correct option here is option D. So D will be the right answer. Question number 129. Which one of the following statement is correct for a minor who has been admitted to the benefits of partnership? Option A, the creditor of the firm sues against the minor's share in the firms for his credit. Such minor sues partners for excess accounts of the firm. Such minor sues partners for share of the profits of the firm. D, on finding foundless in business, he files a case for dissolution of the firm. Here in question number 129, correct answer is option A. A creditor of the firm sues against the minor share in the firms for his credit. Question number 130. A partner wants to dissolve the partnership firm without agreed time. Select which one of the following is not a perfect ground for dissolution of the firm for such partner. Statement A, that one of the partner has become permanently incapable of performing his duties as partner. B, that other partner has transferred the whole of his interest in the firm of a thing party. C, that a business of the firm cannot be carried on except loss. D. That a partner suing in adulterous relationship with a wife of another partner with an apprehensive to affect the business of the firm. Here in question number 130, correct answer is option D. Question number 131. The mode of proof of custom is contained in Section 32 Clause 4 of the Indian Evidence Act, Section 32 Clause 7 of the Indian Evidence Act, Section 48 of the Indian Evidence Act, and all of the above. Here in question number 131, correct answer is option D, that is all of the above. Question number 132. The case of Pakla Narayan Swamy versus Emperor pertains to option A, estoppel, option B, dying declaration, option C, hostile witness, and option D, accomplice witness. Here in question number 132, correct answer is option B, that is dying declaration. Question number 133. The doctrine of estoppel is a option A, substantive law, option B, rule of equity, option C, rule of evidence, and option D, law of pleadings. Here in question number 133, correct answer is option B, that is rule of equity. The doctrine of estoppel is the rule of equity. Question number 134. Presumptions as to abetment of suicide by a married woman has been provided in Section 111A of the Indian Evidence Act, Section 113A of the Indian Evidence Act, Section 113B of the Indian Evidence Act, and Section 113 of the Indian Evidence Act. Here in question number 134, correct answer is option B, that is Section 113A of the Indian Evidence Act. Question number 135. Zahira Sheikh was a prime witness in A. Best Bakery case 2004, Best Bakery retrial case 2006, Sukram disproportionate asset case 2005, Gujjar killing case 2003. Here in question number 135, correct answer is option B, that is Best Bakery retrial case 2006. Question number 136. Sweeping change introduced by Civil Procedure Code Amendment Act 2002 is with the object to option A, give more powers to civil courts, reduce the power of civil courts, cut short delay in disposal of suit, make provisions stringent. Here in question number 136, correct answer is option C, that is cut short delay in disposal of suits. Now let us proceed to question number 137. The rule of dum dupat is option A, rule relating to quanta, option B, rule relating to interest, option C, a rule of res judicata, and option D, a rule of evidence. Here in question number 137, correct answer is option B, that is a rule relating to interest. Question number 138. A commission to make local investigation can be issued under option A, Order 26 Rule 1 of CPC, Order 26 Rule 6 of CPC, option C, Order 26 Rule 9 of CPC, and option D, Order 26 Rule 10 of CPC. Here correct answer is option C, that is Order 26 Rule 9 of CPC. A commission to make local investigation can be issued. Question number 139. The grounds for review have been provided under. Here correct answer is option A only, that is Order 47 Rule 1 of the CPC. Question number 140. A caveat shall not remain in force after the expiry of option A 30 days, option B 60 days, and option C 90 days, and option D 180 days. Here in question number 140, correct answer is option C, that is 90 days. A caveat shall not remain in force after the expiry of 90 days. Question number 141. The classification of compoundable and non-compoundable offence has been provided under First Schedule of CRPC, Second Schedule of CRPC, Section 320 of CRPC, Section 321 of CRPC. In question number 121, correct answer is option C, that is Section 320 of CRPC. Question number 142. A confession under Section 164 of CRPC can be recorded by option A, Metropolitan / Judicial Magistrate, Executive Magistrate, Police Officer on whom the power of a magistrate has been conferred, either A or B. Here in question number 142, correct answer is option A, that is Metropolitan or Judicial Magistrate. Section 164 of CRPC, a confession can be recorded. Question number 143. Under Section 167 of CRPC, for offences other than those punishable with the death, imprisonment for life, or imprisonment for period not less than 10 years, the detention during the investigation can be authorized for the total period of 30 days, 45 days, 60 days, 75 days. Correct answer here is option C, that is 60 days. Question number 144. Where the husband has obtained a decree of divorce against the wife on the ground of the desertion under Section 125, option A, it is no bar for the wife to claim maintenance against the husband. It is bar for the wife to claim maintenance against the husband. C. It may be bar for the wife to claim maintenance against the husband. And option D, either A or C. Here in question number 144, correct answer is option A, that it is no bar for the wife to claim maintenance against the husband is the right answer. Question number 145. This section dealing with the medical examination of the victim of rape is inserted by the CRPC Amendment Act 2005 is सेक्शन 164A ऑप्शन ए है, ऑप्शन बी है सेक्शन से 166A, ऑप्शन सी सेक्शन 166B एंड ऑप्शन डी सेक्शन 53A। करेक्ट आंसर यहाँ पर है ऑप्शन ए, दैट इज सेक्शन 164A। क्वेश्चन नंबर 146। The arbitrator in case of international commercial arbitration is appointed by the option A parties themselves, option B Attorney General of India, option C Chief Justice of India, and option D both A and C. In question number 146, correct answer is option D, that is both A, that is parties themselves, और option C, that is Chief Justice of India। यहाँ पे A और C दोनों आंसर सही हैं, so option D जो है वो करेक्ट आंसर है। Question number 147. An application for setting aside an arbitral award must be by the party after receiving the award within 3 months, 30 days, 90 days, 40 days. Correct answer यहाँ पर है option A, that is 3 months. Question number 148. The provision for the appointment of the conciliator is laid down under section 64, section 67, section 62, section 61. Correct answer यहाँ पर है option A, that is section 64. Question number 149. The Provincial Small Cause Courts Act 1887 came into force on option A 1st July 1887, option B 27 January 1887, option C 5th September 1887 and option D 8 January 1887. So correct answer यहाँ पर है option A, that is 1st July 1887. The Provincial Small Cause Courts Act 1887 came into force on 1st July 1887. तो लास्ट क्वेश्चन है। लास्ट क्वेश्चन को कंप्लीट करने से पहले मैं आपको ये बोलना चाहता हूँ कि अगर आप यहाँ तक आए हैं तो आप वाकई बधाई के काबिल हैं कि आप अपनी पढ़ाई में बहुत सीरियस हैं। इससे ये पता चलता है क्योंकि 150 क्वेश्चंस जो है लगभग ऑलमोस्ट 1 घंटे से ज़्यादा हम लोग रिकॉर्ड कर चुके हैं। 1 घंटे से हो चुका है और 1 घंटे से ज़्यादा अगर आप इस एक ही वीडियो पर हैं, इसका मतलब है कि आपने जो आपका जो अटेंशन स्पैन है और आपका जो फोकस है वो वाकई आपकी जो तैयारी है, आपकी प्रिपरेशन है, उसके लिए आप बहुत फोकस्ड हैं। तो आपको बहुत बहुत कंग्रेचुलेशंस, यहाँ तक आए हैं आप। और अगर चैनल सब्सक्राइब नहीं किया है तो चैनल ज़रूर सब्सक्राइब कर लीजिएगा और इंस्टाग्राम और टेलीग्राम पे भी हमारे साथ ज़रूर जुड़िएगा। और बहुत ही जल्दी हमारी वेबसाइट भी रेडी हो जाएगी, तो हम आपके साथ और मीडियम्स के साथ भी कांटेक्ट कर सकते हैं, आप हमसे जुड़ सकते हैं। तो क्वेश्चन नंबर 150 जो है वो यहाँ पर है, हु इज़ ऑथराइज्ड टू अबॉलिश कोर्ट्स ऑफ स्मॉल कॉजेज? ऑप्शन ए द हाई कोर्ट, ऑप्शन बी द स्टेट गवर्नमेंट, ऑप्शन सी द डिस्ट्रिक्ट कोर्ट एंड ऑप्शन डी द डिस्ट्रिक्ट कोर्ट आफ्टर द कंसल्टेशन ऑफ द हाई कोर्ट एंड द स्टेट गवर्नमेंट। हियर इन क्वेश्चन नंबर 150 द करेक्ट आंसर इज ऑप्शन बी, दैट इज द स्टेट गवर्नमेंट। तो ये था हमारा जो बिहार का 2020 का पेपर, वो यहीं पर ख़त्म होता है। इसके बाद हम जीके के पेपर्स को भी सॉल्व करेंगे, लेकिन उससे पहले हम जो लॉ के पेपर्स हैं उनको कंप्लीट करना चाहते हैं, क्योंकि कई बार जो होता है जीके के पेपर्स में रिपीटेड क्वेश्चंस होते हैं। ऑलमोस्ट हर बार आपको जो नया पेपर आएगा उसमें 20 to 30 क्वेश्चन जो है वो रिपीटेड मिल जाएंगे। तो इसीलिए हम सारे जो क्वेश्चन पेपर्स हैं, प्रीवियस क्वेश्चन पेपर, उनको कंप्लीट करेंगे। तो हमारे चैनल को ज़रूर सब्सक्राइब करिएगा, सपोर्ट करिएगा, टेलीग्राम और इंस्टाग्राम पर भी हमारे साथ जुड़िए। थैंक यू सो मच, थैंक यू फॉर वॉचिंग।